We are live, and whenever you are ready, go ahead, Emily.
Okay. All right. Welcome, everyone. Good afternoon. Welcome to the third installment of our PAGA webinar series. Today's topic is novel PAGA theories and discretionary reductions in penalty awards. I'm Emily Schroeder. I'm a partner at Seyfarth Shaw. I've been practicing in employment law for about 10 years. A big part of my practice is defending employers in novel areas of employment law, like what we're going to be talking about today. For example, in emerging areas under California's Private Attorneys General Act, otherwise known as PAGA. As a quick refresher, PAGA permits employees to sue for themselves and other employees on a representative basis, seeking penalties for alleged violations of the California Labor Code and California's wage orders. PAGA permits recoveries of penalties of up to $200 per pay period per employee and does not require employees to satisfy class certification requirements. You may or may not be aware that California has 17 different wage orders covering various industries, most of which have more than 20 sections addressing things like wages, record keeping, and breaks. Employees can use PAGA to seek penalties for violations of these wage orders. One such type of lawsuit that you're probably familiar with is the suitable seating case, which uses PAGA to enforce wage order section 14's requirement that employers provide suitable seats to employees when the nature of work reasonably permits. Now it seems, unfortunately, that some plaintiffs' lawyers have moved down the list onto section 15, which requires, among other things, that employers provide reasonably comfortable temperatures in the workplace. And that is the area of the wage order and PAGA that I'll be addressing today. Next slide, please, Michael. So here we have wage order section 15 on the screen regarding temperature. It has 4 subsections, as you can see here. The first requires that the temperature maintained in each work area shall provide reasonable comfort consistent with industry-wide standards for the nature of the process and for the work performed. The second section addresses situations where the work itself requires or creates heat, and it requires that employers take all feasible means to reduce that heat. It also addresses situations where the work itself requires cold temperatures, and it requires that employers provide a warm resting room. In the third section, it requires that bathrooms, restrooms, and changing rooms not be colder than 68 degrees. I'm ready to move on to the next slide. The cases we have seen so far largely focus on subsection A, and the plaintiffs have been arguing that work areas that are not air conditioned or heated are too hot in the summer and too cold in the winter, and that this fails to provide reasonable comfort consistent with industry standards. The type of work area that we are seeing targeted is large distribution depots. So this could be depots that facilitate the stocking of retail stores throughout the state, or e-commerce type depots that ship products directly to consumers. Both types of facilities are extremely large warehouses. They're often not air conditioned or heated for both practical and expense reasons. They often exceed 1 million. Oh, I just saw a note that the audio is out. Can you guys hear me? Michael or Andrew, can you hear me?
Yep, it looks like the audio is back now.
Okay, great. How much do you think I cut out for?
You were clear for me.
You were good? Okay, all right. Well, hopefully everyone was able to hear me, and I'll just pick up where I was. So I was talking about the type of work areas that are being targeted in these lawsuits, which are large distribution depots. They often exceed 1 million square feet in size. They have many dozens of dock doors that are used for receiving and shipping product on large trucks, and are thus often open to the outside air or connected to truck trailers or shipping containers that are also not air conditioned or heated. So there's a lot of exposure in these types of facilities to the outside temperatures, and it can be more difficult to control. I'm glad to see that it seems like perhaps only one person had trouble with the audio and left a note. All right, moving along. Employees bringing these claims are also citing to a draft California OSHA rule regarding indoor temperatures. This rule has been pending for more than a year, since April 2019. It would require that employers take certain steps when the work area equals or exceeds 82 degrees, and other steps when the work area equals or exceeds 87 degrees. It also has various requirements related to emergency response procedures for heat illness, training, and heat illness prevention plans. So what we're expecting and what we're seeing is that the plaintiffs are going to argue this draft legislation, this draft statute supports that the industry standard actually requires temperatures under 82 degrees and requires the types of mitigation efforts set forth in the draft statute. So we don't know at this point when the statute will go into effect. The state's website says it's in its final form. And finally, like with other PAGA claims, employees seek penalties per employee per pay period of $100 to $200, though these can be reduced through judicial discretion, as Andrew will be discussing in a bit. Michael, ready to go on to the next slide. Employees bringing these claims seek to represent all employees who have worked in their work area or a similar work area. This could be an entire facility or multiple facilities throughout the state. We rarely see plaintiffs limiting it to their specific job title or their unique work location within a facility. Thus, the main avenue of defense here is to attack the manageability of the claims. Like with other PAGA claims, employees don't need to satisfy the class certification rules, but many courts do require that they show a manageable trial plan. So if you can limit the scope of the employees represented by attacking the manageability of the case, you can also limit the potential penalty award. I'm just going to take a look now at sort of the four elements of subsection A of Wage Order 14, which are the reasonable comfort, the work performed, industry standards, and the nature of the process. I'll start out with reasonable comfort. What temperature provides reasonable comfort is an incredibly individualized issue, as you can probably relate to even in the office environment. For example, one person in the office in the middle of summer might be very, very cold with the air conditioning on. They've got their sweater and their space heater next to them, whereas their next door neighbor in the office is overheating. So this is just one example that we can relate to of how individualized this issue is. In the context of this litigation, you could potentially use experts or declarations from individual employees to highlight these individualized factors, which could include age, weight, gender, acclimatization to the temperature, and other things. So if you can show everyone's reasonable comfort is different, it becomes much more difficult for a plaintiff to represent large swaths of employees on a representative basis. The work itself is also individualized and thus lends itself to attacks on manageability. Some employees may work early morning or overnight shifts when it's cooler. Others work in the heat of the day. Some work in areas exposed to the outside air, whereas others might be positioned right next to a fan and in the shade. These individualized factors will also help an attack on the manageability of the claims. Third, we'll look at the industry-wide standards factor. Here, the employer can take a lot of control in defining what the industry is, because the statute itself is very vague. It gives no guidance as to how to define the industry. So you can look at things like, should the geographic scope be limited to California? Should it be limited to employers of a certain size or workspaces of a certain size? If the employer controls the narrative of who's included in the industry, that can help the employer show that what they're doing is consistent with industry standards. Finally, we have the nature of the process. In the distribution center context, which is where we've been seeing these claims thus far, the nature of the process requires that the work be performed in enormous warehouse spaces that are largely open to the outside air. And thus, practically speaking and expense-wise, it really can be infeasible to air condition or heat the space. These claims, these temperature claims, are still all in their early stages. As I said, they're very novel, so much is yet to be revealed on how they will play out. But this is certainly an interesting area for us to keep our eyes on. Michael, on to you.
Thanks, Emily, and thank you everybody for joining us today. My name is Michael Lafar. I'm an associate in the Labor and Employment Group out of our Century City office. In addition to the temperature issues that Emily's discussed, one sort of relatively quiet area that we've yet to see an increase in litigation for PAGA claims, but that we suspect will rise, particularly in the COVID world, is for violations of the Cal OSHA health and safety laws, which are located in the California Labor Code. And these are types of claims that, while they've been rare, more and more lawyers, I think, on the plaintiff side are discovering this novel theory of liability and incorporating it into the lawsuits that they bring. Many employers in California think of Cal OSHA as, you know, an inspector showing up at a site unannounced or sending a notice for some health and safety hazard or violation that an employee has anonymously reported. And, you know, these types of OSHA claims don't really comport with what we usually think of or see with wage and hour litigation and PAGA lawsuits for wage and hour issues in California. But it's something that's definitely picking up. And one of the reasons for that is also that these types of claims generally cannot be brought by a private individual. It has to be brought either through the division in Cal OSHA itself or now through PAGA as the vehicle for these Cal OSHA violations. So what is Cal OSHA? It's the California Occupational Safety and Health Act of 1973, and the provisions are intended to ensure that there are safe and healthful working conditions for all California employees by making sure that there are effective standards, assisting and encouraging employees and employers to maintain healthful and safe working conditions, and providing for enforcement of those safety and health conditions as well. And so in terms of how that then segues into a PAGA lawsuit, ordinarily an employee will first have to give notice to the LWDA and also to OSHA itself of the alleged violations. The division in Cal OSHA is then required to investigate those allegations. And then one of two things can happen. Either the division will issue a citation and find that there was some sort of unlawful safety and health violation, in which case the citation will be issued and then no PAGA action is allowed. The allegations just end right there. On the flip side, if the division does not issue a citation, then the employee essentially gets their right to sue and can file that PAGA lawsuit. These initial steps are required before the employee can actually proceed with the lawsuit. And it's sort of ironic because it puts the employer in the unenviable position of sort of wishing for the division to issue a citation to then stop the PAGA action from potentially coming forward. And that's because a PAGA action and the potential exposure that an employer can face for the alleged OSHA violations is likely going to be infinitely higher than the actual value of the citation itself. We've traditionally seen Cal OSHA claims brought under PAGA for things like failure to provide a place of employment that's safe and healthful, failure to furnish and use safety devices or safeguards, failure to implement and maintain effective illness or injury prevention programs, which are required in California, or doing anything generally in the work environment that might lead an employee to generally say, I don't feel safe or comfortable here. One recent example that I've dealt with and seen is for a California retailer who faced a lawsuit under PAGA based on allegations that employees in the retail context had to use earpieces and walkie-talkies and radios, and that it was unsanitary to have to share those earpieces and walkie-talkies. The employer did all the right steps by providing alcohol swabs and making sure that everything was cleaned on a regular basis and providing training to employees that they needed to wipe off their earpieces after every use. But it's something that we're regularly seeing in every industry. Emily mentioned warehouse workers. Those are the types of employees that might be using scanner guns, or they might be using radios because they're working in such a large environment. And the employees show up, they pick these pieces up in the day at the time they start their shift, and then drop it off in a pile when they go to take their break, and they come back and they pick up a different one. And so it's really important for employers to make sure that they're taking those steps to identify and root out any causes of what might be deemed as an unhealthy or an unsafe working environment. And especially now in the COVID era, where we're dealing with a virus that is so easily transmittable and oftentimes is unseen because of the lack of symptoms. That's just raised the bar even higher for what employers need to do to make sure that they're not giving rise to some sort of Cal OSHA violations and a PAGA lawsuit that might be filed after that. Some examples of that, for example, are a failure to take individual measures for temperature checks and pre-screening. Employers, I'm sure, have dealt with that in the context of potential work off the clock and dealing with it from an unpaid wages perspective. But it's important to note that that could also give rise to potential Cal OSHA violations and just another theory of liability that the plaintiff's lawyers might want to bring under PAGA. Another example would be a failure to give employees their own equipment. We mentioned the earpieces, the radios, the walkie-talkies. One of the best practices we're seeing that a lot of employers are implementing is, this is Joe's walkie-talkie or this is Sarah's walkie-talkie, and they're going to keep that, and that's going to be their own, and they're going to put it in a designated place when they go out on their breaks. But there's going to be no cross-contamination or cross-sharing of those sorts of equipment that these employees might have to use in things like the retail context or warehouse context. Other examples are failure to provide washing facilities to maintain cleanliness, failure to provide the appropriate levels of PPE, and Cal OSHA in particular requires employers to conduct a hazard assessment to make sure and determine if there's any PPE that's required. We're seeing things like touch screens or keypads that employers have set up for time clock machines throughout the facility. And you might not think about it, but if you have a line of 5 or 10 people that are waiting to use these keypads, they might be spaced out 6 feet apart, but if they're not wiping down the keyboard after every turn, or they've touched their face and then all of a sudden they're touching the keypad or the fingerprint sensor, then you're creating this environment where a plaintiff's lawyer can come in and say, there are germs everywhere, and this is creating an unsafe and unhealthy work environment that gives rise to a potential Cal OSHA violation. And other things we're seeing is maybe employees who have called in sick or who are not taking the appropriate steps to stay home in quarantine, especially in light of the COVID era, and whether that's creating some Cal OSHA violations as well. In terms of best practices and what employers can do to try to mitigate the inclusion of Cal OSHA violations in a PAGA lawsuit, as Emily mentioned earlier with respect to the temperature controls, it's always going to be a little bit difficult, and there are some inherent difficulties for plaintiffs to try and prove their PAGA claims for things like the temperature checks and also for these unhealthy and unsafe working environments. For example, how do you identify which employees were allegedly exposed to the potential unsafe working environment? What days did that occur? And you can speak to employees and you can go out into the field and see what's actually happening. But some of the best practices we would recommend before ever having a lawsuit fall on some legal desk would be to go out and actually observe, do an internal audit. And that's where the attorneys can help. We can go in and identify what potential issues are out there and best practices to stop that. We can identify the hazards and potential pitfalls that might give rise to those unhealthy and unsafe working conditions and take those proactive steps to mitigate it and prevent employees from later going to a lawyer and saying, I saw all these unhealthy things going on in my working environment, and next thing you know, there's a PAGA lawsuit on that. So that's generally the overview for the Cal OSHA violations. There's a question on how the Cal OSHA penalties would be calculated. As Emily mentioned before, the penalties under PAGA are $100 for the initial violation and $200 for each subsequent violation. We would certainly make arguments that to the extent that there is a violation, it would just be once and there isn't a continuing violation. So there should only be a $100 penalty at most per employee. But we're definitely seeing plaintiffs' lawyers making the argument that for every day that you had this unhealthy and unsafe working condition exist, those penalties should be given for each work week in which there is that violation. And that could be week after week after week for thousands of employees. And all of a sudden, you're looking at potentially millions of dollars in exposure. This is a good time to give everybody who's listening or following along the CLE Code. The CLE Code for the webinar today is SS, as in Seyfarth Shaw, 1151. Again, that's SS 1151. And everybody who's attended and who signed up today will also get a follow-up email in the coming days, if not the coming hours, with the CLE submission instructions as well. And Andrew?
Thanks, Mike. I'm Andrew McNaught. I'm a partner in the San Francisco office of Seyfarth Shaw, and I'm going to be talking about the court's discretion to reduce these penalty awards. I'm going to be focusing more back sort of in the wage hour PAGA realm. And although obviously the courts have this discretion across all types of PAGA cases, including the ones we've been talking about, the initial part of this slide shows just sort of the recap that Emily mentioned at the top of the hour, the pay statutory penalty scheme of $100 for initial violation and $200 after that. Sort of some of the overall challenges in estimating these penalties are, that courts haven't decided exactly what is a subsequent violation, as Michael just sort of alluded to. There's also continuing dispute about whether plaintiffs can stack PAGA penalties. In other words, argue for multiple predicate underlying labor code violations in a single pay period. They certainly always try to do that, and there's authority allowing them to do that, but there's some going the other way. But what we're really going to be focused mostly on, or I am now, is the judicial discretion to award less than whatever the statutory maximum calculation might be for these PAGA penalties. And I hope that none of you are ever in the position, obviously, of having to assess this in the context of being on the wrong end of a judgment or order, but it's actually much more sort of everyday, commonly relevant, because in virtually all of these cases that we defend, we are, of course, preparing exposure analyses for the client early on in the case of these claims. So we're wrestling with these issues as we prepare those analyses. Next slide, Mike. And so the discretion that I'm talking about is actually right in the statute, and that's the first bullet point. The courts have this discretion to reduce these penalty awards based on the facts and circumstances of a particular case, and if to do otherwise would result in an award that is unjust, arbitrary, oppressive, and confiscatory. The next bullet point down just shows a bunch of authority standing for the proposition that's outlined in the statute there. And today I wanted to talk more specifically about two recent cases that illustrate some of the parameters of the judicial discretion involved in these awards. The first is a case many of you may have heard about, the Magadia versus Walmart case from the spring of 2019. And then the second one is a recent order of decision that came down this summer called GOLA versus University of San Francisco. Next slide, please, Mike. So the Magadia case became quite notorious. This was a case decided against Walmart by Judge Lucy Coe in the Northern District San Jose Division. The plaintiff had brought a variety of wage hour claims, and there was sort of a convoluted history of the case, but ultimately there was a bench trial in late 2018, and following this bench trial in the spring of 2019, Judge Coe issued this massive damages award against Walmart, largely having to do simply with wage statements. There was a small part of the award that related to PAGA penalties for meal period violations, but that was only $70,000, as you can see in the third bullet point there. But overall, the court's award was, PAGA award was $54 million, and that was on top of a statutory penalty award of $48 million, bringing the total award to almost $102 million. This case, needless to say, is up on appeal before the Ninth Circuit right now. One factor to focus on is that the overall PAGA exposure in this case actually exceeded $130 million if you added up all of the potential penalties under the statutory scheme. So the court sort of explained in its order that, it was actually being quite reasonable by awarding PAGA penalties only at about 35% or so of the maximum award, to the tune of $54 million. This case is obviously an outlier and an eyeball popper, but it's illustrative of the potential, danger that these PAGA awards, and this exposure can reflect. Next slide. I'm going to go very quickly as we're running short on time. There were some defenses. The next couple slides illustrate some defenses that I thought were interesting in the case that the defendants raised. One of which on this slide is whether, Walmart argued that awarding PAGA penalties on top of the statutory penalties would constitute an impermissible double recovery. The court, Judge Coe, basically rejected that argument, largely based on the Raines versus Coastal Pacific case cited in the first footnote here. And so that was one argument that got very short shrift. Next slide, Mike. Another one was that Walmart argued, as defendants often do in response to PAGA claims, that the PAGA penalty award would violate the Eighth Amendment's excessive fines clause and also violate due process. The court also rejected those arguments. It found that the Eighth Amendment was not implicated because the case involved only private parties, even though technically the plaintiff, as a PAGA plaintiff, was standing in the shoes of the state of California. The court sort of ignored that part and said that it didn't matter. And it also found that there was no due process violation. Next slide. Another interesting thing about this case worth pointing out was the expert witness testimony. And in fact, the plaintiff's expert, Dr. Kriegler, in this case, was also the plaintiff's expert in the GOLA case, which we're about to get to. And Walmart also challenged this expert's calculations. And again, the court disagreed and found that the expert's testimony was proper and that he testified at length as to how he programmed his code to arrive at all these calculations. And somewhat astonishingly, I found Walmart did not actually call its own rebuttal damages expert, which the court pointed out. Obviously, this issue is broader than just the PAGA penalties. It encompasses both the PAGA penalties and the statutory penalties. But that was also an interesting point of this case. All right, next slide, Mike. Thanks. And I'm right at the 1:30 hour. I apologize. We're probably just going to need to go a couple minutes over here, and I will go very quickly. But this GOLA versus USF case, this decision came down this summer. This involved a class of part-time adjunct professors employed by the University of San Francisco. They were essentially misclassified, and they were paid on a course rate basis. So, of course, they got wage statements that didn't reflect any hourly pay since they weren't being paid by the hour. They were being paid a flat rate by the course. Eventually, a bench trial happened only on the Labor Code Section 226 claim, which is the wage statement claim, and the court awarded a little over $1.6 million in statutory damages and an additional $545,000 odd in PAGA penalties. The PAGA award here was about 15% of the maximum potential penalty, which would have been slightly over $3.6 million. Next slide. This case, for any of you, and we're obviously not running out of time now, but for any of you that really want to do a deep dive on the current state of the law on judicial discretion and PAGA awards, I would recommend reading this proposed decision. It is very, very detailed, cites a lot of cases and secondary authorities. It's a very thoughtful explication of the topic. You can see the judge identified three main approaches that courts take in all the cases he surveyed: adjusting the percentage of maximum PAGA penalties, which is the directly prescribed statutory procedure, evaluating the propriety of absolute dollars awarded, and then looking at the ratio of PAGA penalties in respect to the actual or statutory damages the court was awarding. This court noted that, all three of those approaches are compatible and that courts often mix and match them, although the first one is usually what the courts end up sort of landing on most heavily. Next slide, Mike. And the court here found, in surveying all these cases exhaustively, that there was really a very wide range of, or sort of market for the awards in these cases that ranged anywhere from 10% to 100% of the maximum penalty award. The court also noted, the bullet points here, some key factors that should weigh on a court's decision-making in respect to using this discretion, and that's the defendant's ability to pay, whether the defendant attempted to correct violations after or before the suit was filed, whether there had been prior complaints about that issue, whatever was alleged in the suit, and whether the employees had suffered no actual injury. And a key point in the award here in the USF case was that the university had never actually changed its pay stubs, and even after, when the award came out, it was still giving what were improper pay stubs. And that was sort of the same issue that was flagged in the Magadia case, that the defendant there, Walmart, still had not corrected the wage statements, even after having been told earlier in the case by Judge Coe that there were problems with the wage statements. So I think those are sort of cautionary factors for everybody to think about. We're about 5 minutes over time, so I'm going to wind up here. And I know that was quite a short summary, but again, if you want to read about it, I would recommend looking at the GOLA case, and you can look at every case on this subject is cited in that case. It's a great source of authority. Well, thank you very much. We really appreciate you joining us. We've now completed Series 3, and we hope that you will be on the lookout for our new date coming up shortly for the next item in the series, which will address motion practice, manageability, and trial plans in PAGA cases. Thanks, everybody.